Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. There has been a stunning, in my opinion, order rendered by Judge Stephen J. Hippler on March 3rd, 2025 that has just popped up on the court docket. And I must say, when you hear what the court has to say here, I hope that you will agree that it appears that this case will finally start taking a turn toward transparency rather than the Mount Everest, as I have called it, amount of documents that have been requested and have been ordered to be placed under seal and therefore kept from the public domain, a practice that both sides, the state of Idaho and the defense, have both participated in, sometimes alone, other times through stipulations, through agreements that they have sent to the court, and to only appreciate the number of filings that are under seal and the stunning amount, you have to go to the Idaho Cases of Judicial Interest website maintained by the clerk of court for the Idaho Supreme Court. Scroll down to Idaho versus Kohberger. Hit the case summary page link. It is the first link that is under the case name and case number for Idaho versus Kohberger. That is the clerk of court for Ada County's case summary page that documents the key events in the case. And look at all the documents that have a lock and key icon next to them. That will tell you what has been under seal in this case. Well, Judge Stephen Hippler's order regarding sealing or redacting filings is available for you to look at on the public docket. You have to scroll down a while to get to March 3rd, 2025, and you will see it there. Permit me, please, to read this order because I believe it's crucially important toward the road toward transparency in this case. It says here, quote, "The parties' pervasive practice of filing material under seal in this case has become the norm rather than the exception. Rather than seeking to redact discrete sensitive information, entire documents are filed under seal. In addition, much of the material the parties seek to seal is already in the public domain or is simply not confidential or sensitive." The pervasive practice that's jumped off this page. This means that it is overly done. It seems like it's common. Sealing records from the public should be the exception, not the norm, is what this court, I believe, is saying here. And also, he is now opining and finding that much of the materials that the parties have sought to seal is already in the public domain. So therefore, if it's already in the public domain, there's no good faith basis, in my opinion, to demand that they be kept under seal regarding this case. Now, this goes on to say, there is a footnote number 1, and it says here, bottom page 1, "Likewise, the party seeking to seal a document that contains the entirety of the information sought to be sealed in the title of the document is an exercise in futility." That's a direct quote from Judge Hippler's order here. It's an exercise in futility because the name of the document which contains the sensitive information once filed is on the publicly available register of actions. So what he's saying here is that there's typically what will happen is there's going to be at least 2 filings. One's going to be a PDF document that you see on the case summary page. That's a public record. And that goes on the public docket. And then whatever it's referring to be filed under seal is in a second document, lock and key icon on the case summary page that tells you that that is a sealed document. What the court seems to be saying here is the description of what it is that you're filing or seeking to have under seal in the title gives away what it is. Now let's go back to the body of this order. Paragraph 1. "This approach runs counter to the public's First Amendment right to know what's going on in its courts." Hallelujah. I have time and time again asserted, in my opinion only, that the First Amendment seemed to always take a back seat when these filings after filings after filings by the defense, by the state or together have said that this item must be filed under seal to protect privacy. In some cases, it was to protect the life and safety of individuals with no further explanation given. Now, how could that be possible if the sole and the correct defendant has been consistently behind bars since December 29, 2022? It's not like he's going to be able to get day passes and go out and effectuate revenge once he learns of this information if it's subject to the public. So what the court is saying here, public's First Amendment rights recognized here as to being important, to know what's going on in its courts. This was a matter that the media coalition who came into this proceeding back in 2023 tried to, unfortunately in my opinion, set aside the non-dissemination order, which on top of all the documents under seal has been in effect because the parties wanted it that way. The parties went to the court with Ms. Taylor's drafted non-dissemination order and asked Judge Megan E. Marshall to put that gag order in effect. And the court entered that order that day. I believe it was January 3rd. It was within the first week of this proceeding. January 3rd, 2023. There were a couple of amendments to it, but that gag order has been in effect in one way or the other on top of all of these documents under seal since the beginning of this case, basically. The court then cites to State of Idaho versus Clapp. This is an Idaho case from 2020, talking about the First Amendment privileges of the public and what the media coalition did when they returned in January 2025 in this case. They were challenging the fact that the motion to suppress hearings and filings regarding the IgG DNA evidence was under seal and closed to the public, and they were arguing to have that information be made in the public domain, arguing they could not do their job because so much of the case is under seal. And they argued this point right here that Judge Hippler is agreeing with and stating that the public has a First Amendment right to know what is going on in its courts. This continues. Consequently, the court will look with scrutiny, this means very closely, ladies and gentlemen, on requests to seal documents simply because they purportedly contain facts that are not public, but that nonetheless will likely come into evidence. Paragraph number 2, page 1 says, the Idaho Supreme Court adopted ICAR 32 to define when public access to judicial records may be denied, including through the redaction and sealing of records. To warrant sealing or redaction, the material must meet specific criteria set forth in ICAR 32I, that is a rule of practice and procedure in Idaho, so as to allow the court to make the findings necessary to justify the decision to withdraw the material from the public. Moving forward, the court will require the parties to adhere closely to this rule and only seek to seal and or redact material as provided thereunder being ICAR 32I. So, it looks like there's going to be a new day moving forward. The court's going to look with scrutiny and make sure that this rule is adhered to, not just by rote, like the court said, 432. He wants specificity. Don't just cite the rule, but then give the reasons why this document that you want kept out of the public domain should be so, based on articulated facts as to why it meets the requirements of this rule. But Judge Hippler's not done. He says, in addition, all proposed orders to seal or redact must specify the basis under ICAR 32I3A for which the sealing or redaction is warranted, a bare citation, ladies and gentlemen, to the rule, or a conclusory summary without an individualized, vigorous, factual and legal analysis of the basis for seeking to have the document sealed will result in a rejection of the request. Wow. What he's saying here is, number one, he wants to see a rigorous, not just off the top of your head, unspecified, but a rigorous, factual, and legal standard here articulated why this particular document should be sealed, or otherwise it's going to be rejected and it's going to be made public. Page number 2, this order continues. Further, the parties must also seek the least restrictive method to protect information that should be or is exempt from disclosure. For example, despite the court's concerns being expressed previously, the state continues to seek broad orders sealing entire documents to protect the identity of individuals rather than simply using initials or requesting that a redacted version be made public that discloses only initials. Wow. I've also noted this, not just specifically regarding this issue with the state, but I have asked, is it possible that if all of the supplemental discovery requests that the state has responded to and that the defense has served, every single document has to be under seal? There wasn't some way to redact just that portion that needs to be under seal and disseminate the rest? So I'm glad that Judge Stephen Hippler is making this point right here. And then finally, accordingly, the state's request to seal filings writ whole, that means entirety, are denied. Denied. It's not going to suffice anymore, is what Judge Hippler's saying, except as otherwise noted regarding certain exhibits concerning grand jury testimony or other exempt records. Rather, those filings have been redacted by the court to refer to certain individuals by initials or family members or of the deceased by their nature of the relationship, e.g. brother. Now, he seems to be, correct me if I'm wrong, but specifying regarding grand jury materials as it relates to possibly people that gave testimony at the grand jury. Let's read this again. Accordingly, the state's request to seal filings writ whole are denied, except as otherwise noted regarding certain exhibits containing grand jury testimony or other exempt records. Rather, those filings, speaking of the grand jury filings, it seems, have been redacted by the court to refer to certain individuals by initials or family members of the deceased victims by the nature of their relationship, e.g. brother, rather than by name. The original filing will be sealed and the redacted versions will be made public. In addition, the court has redacted portions of the defense's filings that contain grand jury testimony. Ordered and dated, 3rd day of March 2025, hand signed Stephen Hippler, District Court Judge. I recommend strongly that you read this order. I provided some feedback here. I provided it here. Go back within this presentation when this order is included. Stop and read the order in its entirety so you can read it for yourself. Or go to the Idaho cases of judicial interest, scroll down to the Kohberger case. I provided a link here, and then go down. You're going to have to go down quite a while to the public records to March 3rd, 2025 to read this order. If you have any comments, any feedbacks, any thoughts, I would welcome all. This will now conclude this episode of the Indie Zone. I want to thank you very much for joining us here today.